first speaker today, who is Ruby Steinbrecher. Hope I pronounced your name right. Ruby has practiced law since 2007, and after 18 years of civil litigation and business law and estate administration, she decided to focus exclusively on estate planning and entity creation. She uses a holistic approach to help her clients preserve their legacy and plan for the future. She's known for her compassion and clarity. Ruby guides her clients through complex legal decisions with ease and empathy, helping them create plans and adapt with life's changes. She's passionate about shifting the way families think about planning, aging, and legacy. So with no further ado, I'm going to turn it over to Ruby. And also in the back, she has copies of her handouts if you would like to get one as well.
Awesome. Thank you.
Why? Oh, there we go.
Got it. Hello, everyone. Thanks for coming. I'm going to try to keep this as lively as possible, talking about some things that don't always feel lively. It changed the screen. There we go. Okay. So, like Paige said, I'm an attorney. I focus exclusively on estate planning. I've done a lot of different things, but really, estate planning has been my primary area of practice for really about the last 15 years. So you're going to hear from me, and then you're going to hear from Beth Merrill, who is a fiduciary. So I'll mention a little bit about how you use a fiduciary in your estate plan, and then Beth will go into more depth about what that looks like working with a fiduciary and choosing one. So this is all about making the right plan. You know, the goal here is keeping your family out of conflict and out of court in the event that you become incapacitated or pass away. So that's what I'll be focusing on. And what we're going to talk about today is the state of California has a plan for you. I'm going to tell you about what that is, why you might want to opt out of it for you or your family. I'm going to talk about simple form documents and when they are appropriate, when they're not appropriate. That's what free will does. But like Paige said, it can often be used as a tool to just get you started, even if you do plan on working with an attorney. And then, of course, I'm going to offer you some next steps that you can take to do your planning so that you, your loved ones, have peace of mind. You're not worried about all the what ifs, and you can do what we're supposed to do here, which is enjoy life and not think about death all the time. And we do that by making a good plan and then setting it aside and not focusing on it all the time so that you can have a good time and live your life while you're alive. So what this is really about is not leaving a mess. You don't want to leave a mess for your loved ones. You don't want to leave a mess if you become incapacitated. I say that estate planning is one of the ultimate acts of love, because you do this because there are people that you really care about. And that person might be yourself. And you want to make sure that there's a plan in place because you've probably witnessed things happening to friends or family when there was not a solid plan in place. And you want to make sure that doesn't happen to you. So it's not just for yourself, it's for your friends, it's for the family, it's anyone who exists in your universe. And then also, you know, traditionally, estate planning had been something we focus on for older people. Older people are the only ones who need estate plans. But we now know, especially since COVID, that we can lose people unexpectedly all the time. We lost so many young people during COVID that was so unexpected. So it's not just that, but it's also, you know, dealing with our unstable markets, our economy being uncertain, and then changes in California law as it relates to benefits that you receive via Medi-Cal, Medicaid, Medicare. Oh, I also want to say, if anybody has a question, feel free to raise your hand while I'm talking. That way you remember your question, we get it answered right away, and then we can move on. So the basics, do you have a plan? If your answer is no, because you have not actively written out your own trust or created your own will or anything like that, you actually do have a plan. How many of you have heard of probate? How many of you have heard of good things about probate? So that's the state's plan. The state has a duty, sort of, to make sure that when people pass away, that your assets are transferred in a legal manner to your legal heirs. And they do that through the court system, through a probate petition. Probate just happens to be one of the best examples of how antiquated and under-resourced our court system is. So probate, I'll talk more about it in a second. And then, yes, even if you have created a plan for yourself in the past with an attorney or a DIY plan, is that plan still good? People often think it's a set it and forget it type of situation, and that's not true. When you create a trust and an estate plan, it's a snapshot in time for that moment. And your life is going to change, and you need to make sure that those documents change with you so that they work the way that you want them to when it's time. What happens without planning? Well, without planning, we're left with a mess. That's ultimately what we're talking about. And messiness means money, time, confusion, and often that can lead to conflict between your decision makers or family members. So I'm just going to briefly go over probate and what that looks like. You know, sometimes I'll meet with somebody and we realize that maybe probate isn't the worst thing for them. That's a very small pool of people that probate's actually appropriate for. But it does happen. But generally, we want to avoid this. So when the death occurs, somebody has to show up and say, how am I going to help Aunt May? She passed away. I don't know where her documents are. I don't even know if she had a will. They have to hire an attorney. They have to come out of their own pocket to pay that attorney. Then hopefully we can figure out what the assets are, decide whether probate is even necessary, file the probate petition, and it becomes public record. We also have to publish notice about the probate. And the whole purpose of that is just to let any unknown creditors know it's time for them to make a claim on your estate. I have heard of probate referred to as you die, you file a lawsuit against yourself so that creditors can be paid. And in some, that's really what it is. So once we get past the public record period, you finally get a court order that gives that person the authority to access your bank accounts, sell property. So then we're into gathering assets. And then hopefully we know where your assets are. So one thing that everyone can do is go home, write a list of the assets that you have, the bank, what kind of account it is, and put it with your important papers. I lost my brother 20 years ago. I was in law school. I was the personal representative of his state. I went through all of his papers. I thought I had everything. 4 years later, I randomly answered a phone call from the Fidelity Unclaimed Asset Department. It was the last phone call they were going to make before it went unclaimed to the state. It was Apple stock. It was worth over $200,000. And my mom is alive and she really could use that money. So we had to open probate again. But if I hadn't answered that call, those assets would have gone unclaimed to the state. So it's really important that you have an inventory of your assets with your important papers. Yeah. Yes, yes. Because probate is required anytime the person who passed away owned real estate in the state of California or have financial assets that exceed $208,850. That's the probate threshold this year. So if any of those assets exist, then your estate is going to go through probate if you don't have a trust. So once we get to the point where we've gathered the assets, hopefully we've found everything, we sell the real estate, then the payouts happen. Your beneficiaries are paid last. That's after the attorney fees, the personal representative fees, all the creditors are paid, et cetera, et cetera. The shortest probate I've ever done took 11 months. That was a miracle. The average length of a probate is about 14 months. And really, your family has no control. The court is in control when you're going through probate. And one of the worst parts about it is the attorney fees are set by a statutory code, and it's a ladder percentage based on the gross value of your estate, not the net value. The court does not deduct mortgages or debts from the value of your estate. Last year I had a probate. The only asset we were dealing with was a house. It was valued at $1 million. He had a $500,000 mortgage on it. The court said, no, this is $1 million estate. The attorney fees were $24,000. So that's what we're wanting to make sure we avoid by doing proper estate planning. So when we don't have your documents in place, your estate planning documents, and when I'm talking about estate planning, you hear this term a lot. Financial advisors use it, insurance people use it, I use it. When I'm talking about the legal documents that are the foundation of your incapacity plan and your stuff and what happens after you die. So your incapacity plan is your power of attorney, often called a durable power of attorney, and your healthcare directive, also known as a healthcare power of attorney or an advanced healthcare directive. Those two documents are only effective while you're alive. So that's when you're incapacitated. You can't make decisions on your own. You need help. You want to choose who's making those decisions on your behalf. That's often when we use a fiduciary. So if you don't have these documents in place, then that means that somebody has to go to court to get authority to make decisions on your behalf. But as I said before, our court system is very antiquated. Everything takes forever. You have to hire an attorney to go to court for you. It's very, very expensive. So it's not only about what decisions are being made, but who's making these decisions? And are they the decisions that you would want? So by having a power of attorney, it avoids conflict, makes sure bills are paid on time, nothing goes into default. And then, of course, with your advanced healthcare directive, it names exactly who is allowed to make these decisions on your behalf. So it isn't some child or family member who you would never want making those decisions on your behalf. Wills versus trusts. What people often don't always realize is that a will is instructions to the court. That is its sole function. It tells the court what you want to have happen with your stuff. The name of the game here is avoiding court at all costs. So if you have assets that exceed that probate threshold, and that was real estate or $208,850 in financial assets, then you need a trust. So a living revocable trust is what is most common. And it's called that because you create it when you're alive and you can revoke it, change it, amend it, do whatever you want with the trust while you have capacity, and do whatever you want with the assets that are yours, that are titled in the name of the trust. So with going to court with a will, again, there's very little control. If we're dealing with minor children, it just has very basic appointment of who the guardian is that's going to raise your minor child. Doesn't go into the kind of detail that you probably have in mind about how you want your child raised. And then there are opportunities for asset protection when you create a trust. That's not asset protection for you. That's asset protection for your beneficiaries. So these are the 5 core documents of a comprehensive estate plan. We do lots of other documents included with this, but this is the essentials. And this is what you would want to be looking for as you're doing research online or talking to other attorneys. So of course, your will, instructions to the court, and then your trust keeps you out of court. I always create a will when I create a trust, and it's called a pour over will in that situation. And it acts as a backup. It's there just in case you forgot about an asset or an asset got taken out of the name of the trust and then you pass away. So that will is there just in case something does need to go through probate, but the will names the trust as the beneficiary. So that way it gets poured over back into the trust. And we make sure that your beneficiaries receive their gifts when you have decided, because the trust is where you put in all the details. Like, I want this used for education for my grandchild, and they don't get any money unless they finish school, or the money goes to a charity after they finish school, whatever the case may be. And then the power of attorney and healthcare directive, again, that's your incapacity plan. So power of attorney, we usually do a durable power of attorney because it's much more detailed. That is where you authorize someone who can handle all of your legal and financial affairs on your behalf. And that's you could be home with the flu, or you could be in the hospital for a month, but you're going to get better, be able to take control again. Sometimes, though, it does become that your power of attorney is acting on your behalf, and then you became permanently incapacitated or pass away. And that's when your successor trustee steps in to carry out the terms of your trust. And as I said, we do something called a kids protection plan, and that's for minor children, where we just want to provide a lot more details than just who's raising my kid. This is how are you raising my kid? What are the family relationships you want to make sure are maintained for my children? What community do you want to make sure that they stay in, or educational or spiritual beliefs that you want your child raised with? Oh, yes, sir.
Going back to the previous slide.
This one?
Yes.
Okay.
All these documents that you're referring to, how does one have it in place somewhere? What's the best place to put it? Because it's like if you're incapacitated, you may not remember where you put it, or if you're very disorganized,
Yeah.
it's all over the place. What's your secret tip?
Well, my secret sauce is that if you work with my office, we have an electronic online portal that is yours, and we keep all of your electronic signed documents there. But what we do when we create your plan, and this is something anyone could do, you don't have to work with my office to do it. You write letters to all the people who've been named who are going to have a job. Your successor trustees, your power of attorney agents, your healthcare directives. So when you create the documents, you let them know, I've created this document, I've named you in this role, and this is where you can find the document when the time comes. It's about communication. And so much of proper estate planning is about communication. And if you don't have anybody in your life, that's when it's so important to have a fiduciary that you bring on board who knows you, understands where your documents are, and can be there when that time comes.
Thank you. Now the healthcare directive.
Yeah.
You're indicating here healthcare directive and the power of attorney works best when you're alive and able to.
It only works when you're alive. It becomes null and void upon your death.
Surprising, yes.
Okay, great. Thank you. Okay. How many of you have heard of this term, the silver tsunami? Did you know you're it? You're the silver tsunami. So we have got huge numbers of people turning 65 every day right now until the year 2030. There is a big transfer of wealth happening. It's why it's so important to be doing proper estate planning. And there are so many opportunities to provide for your kids. How many of you have heard of Prop 19? Okay. Are some of you more familiar maybe with Prop 13? Yeah, so Prop 19 essentially replaced Prop 13, and it made it more restrictive, unfortunately. So this is about the transfer of real estate and preserving that tax base so the property taxes don't go up. So what Prop 19 does is if your property, your primary residence, it has to be, is transferred to a grandchild or a child, they have to move in and make it their primary residence within 1 year of your death. We file the proper Prop 19 exemption paperwork with the county recorder on your title, and then they're able to keep the property taxes from going up to the fair market value at date of death. Because when someone inherits property, their basis becomes fair market value at date of death. And the whole purpose of that is so they can turn around and sell the property and not owe any capital gains. And so many people, probably many people in this room, have owned their home for 20, 30, 40 years, and your property taxes have stayed relatively low. If they were to go up to the new county assessed value, that's why many of your kids and grandkids can't afford to stay in Marin County, because those property taxes are so high. So Prop 19 is an opportunity to help your kid or grandkid stay in your home and stay local. Like I said before, there are opportunities for asset protection that you can build into your trust for your children. A level of asset protection that you can never have as a California resident unless you just give all your stuff away. And then one thing that people are often not aware of is that, after you're 65, you're eligible for Medicaid benefits. And oftentimes that includes long-term care, but Medicaid can do something called clawback, which means they seek to get reimbursed from your estate when you're gone for everything they paid on your behalf. The average Medicaid bill, because when you need it, you usually really, really need it, is about $300,000. Fortunately, in 2017, the law changed. So now they can only seek clawback, they can only seek reimbursement from assets that go through probate. So as long as all of your assets are in a trust, you get all the benefits and they don't get paid back anything. It gets preserved and kept for your family. And then we just throw this on here about having your kids help you pay for estate planning because it comes up a lot. A lot of folks are house rich, cash poor, and want to do this and know that it's going to cost a lot less than probate, but maybe you don't have the cash on hand to actually do it now. Your kids are going to be the ones who ultimately benefit from this. So if you want to get it done properly and help them, then they should help you pay for it to make sure it's done properly and they get the maximum benefits. So, yes.
You can't deduct anything from your what I was going to say. You don't have any deduction. They can't move in.
Right. Yeah. So then you're not worried about that. So what your bigger concern is, who's going to be handling these things and who's going to be making decisions for you if you become incapacitated or pass away, and who's going to make sure that your assets go where you want them to, because you probably don't want them to go to the state. You'd rather have them benefit a cause or an organization or other people that you care about. And that's where a fiduciary comes in, and you'll hear more about that in a little bit.
We had another question.
Yes.
If you have a trust and
Yes.
in it you have put your two children to inherit 50-50 on your home, can they decide amongst them if one of them wants to move into it and get the benefit of keeping the property tax at the lower rate?
Yes, but there's some hoops you have to go through. So for one thing, is there a mortgage on the house? So if there's no mortgage, then we have less of a concern. It's about making sure that the other child who's not moving into the house gets an equal share. So if your house is the primary asset, then most likely what they're going to need to do is take out a mortgage so that they can pay their sibling their equal share of their inheritance. But absolutely doable. So even if you leave it to two kids, we can do the proper paperwork. We can have a waiver disclaimer from one child to the other. And the one who decides to stay in the house, they move in, make it their primary residence. We do all the proper paperwork. Boom, they get to keep the property taxes low. It really just comes down to equalizing the gift to the other child.
So if you have financial pensions, IRAs, stock,
Then they would get more of that to equalize.
and you can say that.
Yep, absolutely. Yeah. Thank you for that
And
question.
LTC, is that long-term care?
Yes, thank you. Long-term care is one of the biggest benefits that people are utilizing after 65 for Medicaid, because many people don't have long-term care insurance, and that's pretty much the only other way, unless you have money to pay for that long-term care. Okay, Susie Orman. I think she's done an awesome job of making everyone aware of estate planning and familiarity with these documents. And, like I said before, free will, all these programs, I don't have any problem with them. I think that they're super duper helpful. You just have to be cautious because you don't know what you don't know. And it is absolutely appropriate for many people who have very simple estates, when maybe that's not a blended family, not significant assets. We're not dealing with out of the box assets like mineral or oil interests, which I see once in a while. It all works for that. But you do get what you pay for. So if you do have a situation that's maybe a little more complicated, then most likely it is more appropriate for you to work with an attorney. But if you can't do anything, this is better than nothing. Having something in place is very, very important. So if I get a lot of single women clients who come to me, and oftentimes they don't want to name their adult children because they know it's going to cause conflict between their other kids, or they're just not, they don't have the kind of skills that you would want for someone in that role. So this is why that you would use a licensed fiduciary. And we're going to hear from Lori Beth. The advantages of using a licensed fiduciary is that it takes all the emotion out of it. Your family, your kids are grieving. They're going through major life changes. And then to also ask them to be making these major decisions about your estate, and especially if it's one child and then you've got other kids who are beneficiaries, you're just opening up a potential for conflict between them. So it's really good to consider this as an option. And then also, giving to causes you care about, just because, who wants your estate to go to the state? You don't want it to go into the California General Fund and they're not even fixing the road outside of your house. You want to make sure that it's being really utilized for the things and people that you care about, like Vivalon. So here's some common myths I hear a lot when I'm talking about my role as an estate planning attorney. You only need to plan if you have money. Well, I think I made it pretty clear. Everybody needs, at a minimum, a power of attorney and an advanced healthcare directive, because anyone can become incapacitated. And you want to make sure that the people you choose are making decisions on your behalf, and that they're the decisions that you want, and that you've communicated those to people. And also, it's very expensive to go through probate. So even if you don't have money now, this goes back to your kids are going to benefit from this. So maybe it's time to ask them to help participate in paying for this and making sure this gets done. My spouse gets everything anyway. Number one, that might be true if every single one of your assets has both of your names on it. I had a client last year, we just wrapped up her probate yesterday. Her husband had been dealing with cancer for the year prior. They had, done everything they thought they needed to do. They put her on all the accounts. They made sure that there wasn't going to be any issues. About 6 months after he passed away, they discovered a brokerage account at an old employer that had only his name on it. And we had to open probate for that one account because it was worth over the probate threshold. So you don't really know if you've got everything. And also, even if your spouse could get everything, don't you want to participate in deciding what happens to the assets after your spouse passes away? Don't you want to have some agency over which kids are going to be in charge, or who's going to be deciding what and what they're getting? So those are all really important. And then finally, I don't have the money to pay an attorney for this. This really goes back to the first one. And probate's going to be far more expensive. It's going to be difficult when you're in the fog of grief, having to go through probate and dealing with attorneys and dealing with making decisions about assets. It's really, really hard. I did that 20 years ago when I lost my brother, and I just couldn't believe that you had to do this. It made me so mad that I was in the midst of deep, deep grief, and I had to sign papers and read things and understand them and make these major decisions. It just felt wrong. So that's another reason why you want to make sure you do this ahead of time. So these are some things, this is what we do at my office, but I also just, as a general, PA, that these are things that you should be thinking about when you're talking to any estate planning attorney or when you're doing your DIY documents. This is really important. When you create an estate plan, it's a snapshot in time of that moment. You need to make sure that thing stays up to date. That's one of the number one ways that plans fail, is because somebody did their plan 20 years ago. They wrote some notes in pencil on it, hoping that those changes would be actually effective. It's not. You're not supposed to write on those documents. If you have legal documents that are notarized, writing on them only makes them not work. So it's really important. So if you have an estate plan, if you've done planning, set a reminder on your phone for every 3 years to look at your documents, look at your assets, make sure everything is still current. If you have a trust, your assets need to be titled in the name of the trust or need to be the pay on death beneficiary after a spouse if you have one. It's so, so, so important to make sure you regularly update your plan. I already talked about that asset inventory. Yes, she's coming with the microphone.
So I happen to have brought my
Your
trust with me, and it's 10 years old,
Okay.
and a lot of things have changed. So this is my 10-year check-in. So how do I do that? How do I update my trust?
Okay. So is your original attorney still around?
I don't know. I don't know. Maybe.
I would start there, because you would start with your original attorney, because it's always going to be better to continue to work with the person who originally created it, because it'll be less expensive and they already kind of have some familiarity, hopefully. I mean, it was 10 years ago, you never know. Or even if they've retired, they might have sold their practice to someone and they still have all those files. So that's the first place to start. And then if you have no luck and you're not able to find them or their successor, then you find an attorney you like. That's it. And you go to the attorney. And if you were to come to me, we would review your plan. We talk about what you need. And then I'd quote you a fee on what it would take to update the plan. And that's it. So I always say start with your original attorney. And then this asset inventory, this is something we do as part of the process when you work with my office. You give me all your asset information. I create a nice little document that you can take home and put it with your important papers. This is not a typo. $13 billion went unclaimed to the state of California in 2024. And that is because we can't find your stuff, or you did not leave a will or a trust and you have no legal heirs. That's what happens. It goes unclaimed to the state. And I know most of you would rather have it go to causes you care about rather than going to the state.
So what happens to the unclaimed property? Does it stay with the state
Yeah,
indefinitely?
they put in their general fund and they spend it. It's gone. Yep.
So I know the state has a site where you can go look
Yes.
to see if there's any unclaimed property.
Mhm. They have a certain window. I don't know the exact time frame, but they'll keep that property on their site for people to be able to make claims on it. And then after a certain point, it just goes into their general fund.
If it's just say a bank account, maybe a refund check or something of that sort, it may not amount to much. But
Yeah, we recently did it. Some of our staff people did it. She found $2.30 from an old bank account from college. And so she's like, the state can have it. So you can Google unclaimed property, state of California. It'll take you to that site and you can put in your name and info and see if there's anything there. Yes, sir.
How many people title their house in the trust? In other words, they use the name of the trust as the title for the owner of the house.
So anyone who's done proper estate planning and have done their trust, if they worked with an attorney who knows what they're doing, their house is titled in the name of their trust. Because it's almost pointless to have a trust and a house if you haven't titled the house into the name of the trust. Yeah. Was there another hand? Okay. Yeah.
I have no friends willing to write my checks if I'm briefly incapacitated. The friends fear the money obligation if my funds will be depleted, although they won't. What other options do you suggest? I do have a trust.
That's where a licensed fiduciary comes in. A licensed fiduciary is trained, licensed, and bonded to do that for a living. And we're going to hear a lot more about it in just a few minutes. Yes.
How much younger should I have a fiduciary
how much younger should I ask should a fiduciary be than my own age? I mean, I'm 86, so I'm fearful that my fiduciary or my lawyer or whoever else is going to be helping me might retire or whatever the situation is.
Yeah. Yeah, that's a great question. So there isn't a specific age. They need to be X amount years younger. It's more about how they've structured their business. So when we hear from Lori Beth, she's going to talk about, she has a firm with other fiduciaries who work with her who are even younger than her. I have a succession plan. You should make sure your estate planning attorney has a succession plan, so that if something happens to me, someone will step into my shoes and continue to be able to assist clients. And there was a question right here.
Do you do special needs trusts if you have someone in your family that you need to have a special needs trust for?
Yeah, so what we do is we build special needs trusts into your trust so that it gets triggered upon your death. If you have someone right now that you would like to set up a standalone special needs trust for, then I actually recommend Stacy Turner, who's in Marin, and she specializes in special needs trusts. But if it's something that gets triggered upon your death, then that's something that I can do.
I don't quite understand what the difference is of, I mean, I understand like one is if the parents pass away and then there's this other.
The standalone special needs trust would be, are there funds right now that are going to be used for this person? And if you deposited them in their bank account, then it would totally screw up their benefits. That's when you're going to set up a standalone special needs trust for them right now. Versus if you bake it into your trust, then that does not get created until you pass away and the gift passes to them. Does that make sense? And we had a question right here.
Thank you. I don't, tell me if this is an appropriate question. I don't want to embarrass you, but I'll ask it.
Yeah.
Generally, how much would it cost to come work with somebody like you, arrange?
Mm-hmm. So I start will-based plans at about $3,500. Trust-based plans start at about $4,500. You can find attorneys out there who will do it for a little less. You'll find attorneys out there who will do it for more. I'm really big on comprehensive planning and doing more than just documents. That's where we do the legacy interview, where we get to film you so that we have something to pass along to your family. We do those fiduciary letters where we write letters to everyone who has a job so they know what to do when it's time and they know who to call to ask questions when it's time. So there's a range, but usually it's within, I'd say the lowest I've seen is probably $2,500 to $3,000, all the way up to $7,000, $10,000, $15,000 for very sophisticated trusts.
Are succession plans a requirement from the Bar Association?
No, but they should be. Yeah, right now, I was just talking to Lori Beth about this. We're with this silver tsunami. We've got so many service professionals who are retiring right now. It's so hard to find a CPA. I get phone calls all the time. Oh, my estate planning attorney, I called the number. It's a dead end. I can't find them. I don't know what happened. I didn't get a letter. So to me, it's terrible. I would never put my clients in that situation. So that's why it's really important to talk about succession planning for your service professionals. And then I think more and more of them will realize how important that is for their own business.
Yeah, but most people in this room, we've gone through this rodeo once before.
And that's what happens, right? Yeah. So that's why that succession planning for your service professionals is so important. Yeah. We had a question over here.
My question is about probate. I have a couple of retirement accounts with a designated beneficiary. Are those also subject to probate?
If your designated beneficiary is not alive.
Okay.
So
alive last time.
Fantastic. And so my thing is I'm all about, if we're planning, we're doing very comprehensive planning to plan for what if something happens to them. And so what I usually recommend with retirement accounts and things like that is you name your primary beneficiary who you want to get it, and then you name the trust as a backup so that no matter what, it's not going through probate. Okay. Oh, yes. Hello.
What's the definition of DIY?
Do it yourself.
Okay.
Okay. Oh, hello.
So if you, on your investments, you have a primary, but then they usually ask for secondary,
That's where you name the trust.
not your kids.
Well, so if you have a spouse, you always name your spouse first.
Yeah.
But you name the trust second, even if it's going to the kids, because it doesn't really make a difference with the tax implications. Our Secure Banking Act that passed last year changed the way retirement accounts are taxed. So if you have a spouse, you always want it to go to them first. Anybody else, it basically triggers a 10-year mandatory withdrawal period. So that's why naming the trust is better overall, because then you've got all the backups included in the trust. Okay.
That was a good question.
Yes, I like to ask again about probate. If one account, let's say bank account, is out of trust, okay, and on the bank account is beneficiary, let's say not the spouse or some, how the probate, it has to go to the probate?
No, if you have a designated beneficiary and that person is alive when you pass away, the bank will cut a check directly to them.
Oh, just directly.
Yep.
Okay.
Yep.
Doesn't need to go to.
Nope, it does not go through probate if you have a designated beneficiary.
Okay, and I mean, the trust we have to have for husband and wife separate?
No, when there's a married couple, we do what's called a joint trust. So it's one trust for both of you. And then the survivor of you remains as the trustee and the trust stays in effect.
Thank you.
Yeah, you're welcome. We had a hand raised over here first and then to over there. There was somebody back here I saw. Yeah, wait in the back.
Yeah, I was just trying to figure out, so let's say I have a retirement account and my only beneficiary is my daughter. So you're saying they would cut a check, probate's not involved, and let's say I wind up being less than a threshold of 208. Just get back to me on that.
Yeah, so as long as your daughter's alive, they'll cut a check to her. If she is not alive, God forbid, and the amount is less than that 208, then you're next in line, legal heir, if you don't have a will or anything stating who you wanted to go to after your daughter. They would do what's called a small estate affidavit. It takes a little time. You have to deal with the annoying bureaucracy, but eventually they'll get the check without probate.
You've got to have a secondary.
Yeah.
Indicated
somewhere.
What if your primary beneficiary is not your wife, your partner?
Okay, so if your primary beneficiary is your partner, and you're talking about beneficiaries on retirement accounts, I'm guessing.
Well, I have no retirement accounts, which would just be from the sale of the house, whatever assets I have willed to her.
Yeah, so you would actually want to do that in a trust because it is real estate. And so you would want to designate your partner as your primary beneficiary. And then you would name backup beneficiaries in the event that your partner was not alive. Or we can also put other conditions in there that says, if you are not partners at the time of your death, then it's going to go to this other beneficiary.
I see.
Yeah.
Thank you.
You're welcome. Yeah.
Let's say that we do what's necessary and we put everything in the trust and so on and so on and so on. But later on, after we're gone, how do we know that it's going to happen the way we say it's going to happen?
Well, number one, you won't know This is why it's called a trust. Yeah. We'll finish this question. Did you have a question, ma'am?
Oh, okay. If you have an account, several accounts, a regular account, you can put your children into the account without even having trusts and everything else.
Correct.
Oh, okay.
Yes.
I mean, if at the time you want to just put them on there, if the whole account will go to the whoever it is.
That's exactly
Usually-
right. Yeah, I just call that short-term estate planning. It's not comprehensive estate planning. Let's do one more question and then let's hand it over to Lori Beth.
So going back to retirement accounts, my daughter's the beneficiary, but the retirement, it's a deferred comp, and so that you get a certain amount every year. Does she have to take the whole amount out and pay tax on all that stuff, or can she be in what I would have gotten yearly?
Yeah, so usually those terms only apply to you or your spouse. And it also just depends on the policy and what's written into your deferred comp policy. But generally it triggers a 10-year mandatory withdrawal period. So she would need to work with a CPA and be like, how are we going to time this to minimize my taxes? So I'm going to be around for a while after our presentation here. I really appreciate all the questions. And if you want to schedule an appointment with me, you can talk to Francis, who is in the striped white jacket in the back. My office is in Sebastopol, but I'm set up to do Zoom, and I'm happy to be here, and I'm happy to hand it over to Lori Beth. Thank you.
Thank you, Ruby. My apologies to everyone on Zoom. For some reason, the camera quit working and I couldn't show you Ruby. But I am happy to introduce now Lori Beth Merrill, who's a private licensed fiduciary in the state of California since 2018. She holds an undergraduate Bachelor of Science degree in real estate. She holds a Juris Doctor degree in law. She has extensive government experience with appraising real property and change of ownership issues. She's a member of both the Professional Fiduciary Association. Oh, the president. Oh, excellent. And she is also a part of the National Guardianship Association and is equipped to provide critical services to seniors, persons with disabilities, and children. She manages matters for clients, including daily care, housing and medical needs, and also offers financial management services ranging from basic bill paying to estate and investment management. So please welcome Lori Beth. And I'm going to get her screen up.
Yeah, hi. Yeah, I didn't do that. Whoever yeah.
We're having technical difficulties.
It's all right. Thank you.
All right.
So, okay.
And I apologize about the camera. Yeah. I don't know what is happening.
Yeah.
I've tried everything.
Well, so just so you know, Ruby and I, we are colleagues. We know each other. We work together well. I've been honored and pleased to be named in many of her estate plans that she has worked together to make sure covers all these assets, and so that you don't have to worry about something falling through the. It is. Is it? Can you guys hear me? Yeah, they can hear me. No? I can hear you. I don't know. I just don't want it to echo. Is that better? Yes. Okay, great. No worries. Yeah, I'll turn the little one off.
Free yourself from the microphone.
No worries. Oh, there we go. Okay, no worries. So I'm sure many of you have heard the word fiduciary, but you haven't necessarily heard it in this context. So I am not a Securities and Exchange Commission fiduciary that deals nationwide in only financial matters. I am here with the state of California under their oversight. And as Ruby mentioned, I am licensed, I'm insured, And if you put instructions in your estate plan that you want me to be bonded, I can be that as well. Fortunately, the state of California requires that I perform several tasks. Every single year, I have to report to them, every one of my clients, how much money I start with and how much money I end with. So, and under probate code and the 16,000s, I have to do what's called accountings. Any monies that I touch or could touch, I have to account for every single penny in these very formal reports I provide to you or whoever you designate. That could be your CPA, family members, etc. So there's nowhere to hide the money, you know, not that that's what we're trying to do anyway. We're complete transparency. So yes, I know that Betty online had said she was concerned about having no friends. You know, what if she was temporarily incapacitated? Who could write those checks? That would be me, professional fiduciary. And what Ruby was saying, if you have nothing, at least have that power of attorney for healthcare in place, have a durable power of attorney. The durable power of attorney can be simple or it can be extensive, depending on what you want. And these documents can take effect immediately. It's not like the movies where we're going to come in and take over your life and take your money and lock you away. I only show up when I'm invited or when there's an emergency situation. And then if you were to get well again, I fade off. You know, so I've had clients who've broken their hips. I've helped them out for a month or two. Everything's good. I fade out. So just wanting you to understand why you would want to even consider professional fiduciary services. So again, we're not just the money. We're named agents on all these documents that Ruby had up earlier. And we benefit every family configuration, every situation. And so I want to get into some of the different types of family configurations after I make sure you guys understand we're licensed, and as such, we have to act in your best interest. We are legally bound to put your needs ahead of our own. So it's not like we're you know, a financial advisor who might be making a commission on selling you certain types of products. We literally step in your shoes and we have a worldview of what would be the very best thing to do for you, economically, emotionally, physically. So we specialize in managing estates, trusts, and healthcare decisions. And those documents give us the authority to do that. We provide objective professional guidance, and this avoids family conflicts. And again, we're licensed by the state of California. We have to do continuing education. We pay a lot for our license every single year, so we take it very seriously. And so again, just as a review of the documents, not to belabor it, but once Ruby has done, and she takes her time and she misses nothing. Once these documents are done and they're in place, we are the ones in the trenches, as it were. We're the feet on the ground, actually acting as your agent under these various documents. So a living trust is only going to come into play if you name me as a successor trustee, for instance, if you were to lose capacity, or obviously after you pass away, and that covers trust assets. The financial power of attorney covers non-trust assets. So for instance, most people don't put their checking account in the name of the trust because it's just their checking account. Hopefully they've named a beneficiary. But so between these two documents, all your assets can be dealt with by a professional fiduciary. And I love how they have so many words for the same documents. The healthcare power of attorney, the healthcare directive, and not to be confused with the pink post that's hopefully on your refrigerator. because that document, which we also deal with, is for much more emergent end of life decisions. These are more your everyday decisions. Allow us to call and make a dental appointment for you, or give permission to have a surgery if you're unconscious. These type of real life situations that come up. And so the pour over will is just a really great safety net for all the personal items and anything else that didn't make it into the trust. That says, treat it as though it were in the trust. And also, I don't have up here is that asset protection that Ruby was talking about, but I really want to emphasize that because many of us, it's becoming more and more increasingly diagnosed that people are what I call my special flowers, and they need special needs trusts. And so we also act as trustees for special needs trusts. So that's really an important thing, to make sure that we are only spending on the things that the government allows, not to obliterate your special needs trust recipients' benefits. So I want to go through a couple different scenarios, and a lot of it is going to seem repetitious, but hopefully repeating it in different ways enough times will kind of anchor with you, because I do understand that this concept of professional fiduciary is new. So if you are a childless adult, which I am coming more and more in contact with people who's, whoops, we forgot to have kids. We couldn't have kids. We never wanted kids. We're sailing the world, haha, because we didn't have to spend money on kids, which are very expensive. You don't have that natural heir apparent to handle your affairs, okay? And distant relatives, they might not understand your wishes. Maybe you see them once a year at a holiday. They don't really get you and what you really want. And friends, God bless them, but they might feel really uncomfortable trying to help you out. And here's a real danger point. I've seen a lot of well-wishing people want to help their neighbors or their friends. Don't do it. You are held to the same fiduciary standards as I am. Only you're doing it without a license, without insurance, without a bond, and you could really get into serious trouble for doing that. And so maybe you just have no one who is willing. You've asked, hey, how would you feel about this? And they're like, yeah, so you don't have anybody. So, and then if it gets to a point where the court has to get involved and appoint somebody for you, who's that person to you? I would much rather take time, get to know you, know what you want, and go from there rather than some stranger be involved with you. So, you know, we ensure that your wishes are honored, and we will understand your value after you go through our onboarding process, which is quite delightful, actually. So the living trust benefits, we manage your estate, we will protect your assets, and so a lot of people say, well, you're not that kind of fiduciary, but sometimes we do hands-on investing. But more than that, we oversee your advisors. We're here to foster your relationships. What does that mean? You've built decades. You have your favorite tax preparer, you have your favorite advisor, hopefully your favorite estate planner, and we want to keep all those relationships intact. However, if you don't have somebody, we have plenty of great people that we do work with. And if they're not meeting your goals, we can, you know, do something differently to make sure that your future is intact. So what we love too is the charitable giving. That makes us really happy, because if you have no kids, it's not going to kids, it's going to charities. And we get very excited to fulfill those wishes. And then, you know, there's no family drama because, you know, save the drama for your mama. We take, this is what we sign up for, to take those heated thoughts, feelings, and comments and questions and answer them. And we, again, as I said, we can manage discretionary trusts. But without a fiduciary, again, the courts can appoint somebody who doesn't understand your wishes. And it can be delays and doesn't reflect your values. What's up?
I believe you mentioned that you being a fiduciary, you would manage the estate. But supposing we have our children in there, how does that work?
Yeah, we'll get there. We team up with them. We don't replace them. We work with them, and especially if that's your desire. I have a whole range. Some people are, my kids are terrible. They waiting for me to circle the drain. They're drug addicts. They live far away. They're too busy. You know, many different classifications of children. Or my child is wonderful and I love them, but they're clueless about these types of things. So whatever your configuration is, we figure that out when we get to know you, and we respect the level of involvement that you want us to have before, while you're healthy, maybe when you're experiencing a health event, and then, after you leave the planet. And that's how I phrase it, leaving the planet. So moving on to, the childless adult, the healthcare power of attorney, we advocate for your medical preferences. And we realize it can change. I have a client right now who was, let me die. Well, now she's in the hospital. Do everything you can to keep me alive. And you know what? That is okay. Because until you've faced death, you don't know what it's going to be like. But we are there to make sure whatever your wishes are, they are adhered to. We're your voice when you can't speak. So that's super important. And the financial power of attorney.
You have a question back?
Yep.
Can you please tell me about successor executors and about beneficiaries overseas? Thank you.
Sure. Well, executor, so the terms of art, executor goes directly to somebody who has a will only, or a pour over will, which is kind of a residuary document that just really feeds into the trust. But an executor, as Ruby was saying, you're going to name whoever you want as an executor, and then you're going to have some backup folks, hopefully, because otherwise somebody's going to have to get appointed. And overseas, it really depends. So like if they're in the military or what, it depends if they have property here in California. That's what really ties the need to have a professional fiduciary licensed in the state of California is, where's your property? Where's the bulk of your estate? So I would need a little bit more to understand what they're asking, which I'm happy to do. But I just, again, these going over the documents, I really want to get these documents docked in your mind. The healthcare power of attorney, the financial power of attorney, again, that's for non-trust assets. And depending on how it's worded, it can be simple or extensive, the pour over will, and then widowed individuals. Normally on estate planning documents, people have a tendency to name their spouses. Well, that's great. What's your age difference? So you guys might be failing at the same time. Maybe one's getting Alzheimer's and the other one broke a hip. It's not realistic to think that your spouse is going to be in any better shape or abilities to handle what's going on with you and your decisions than you are. But then when you're all alone and you're widowed, it's kind of you're all alone in the world. And again, unless you have somebody who does this for a living, you're kind of out of luck. And then, while Ruby is beyond competent, she's not the cheapest one to do it, the cost-effective way. And so, again, adult children may live far away, be too busy. And it's an emotional burden that people aren't usually willing to take on in a difficult time. And then the kids are fighting. Well, mom wanted to stay in the home. Well, I think she should be in a facility. Well, dad, he was on a silver alert the other day and the police brought him home. I mean, the scenarios are endless. So again, financial decisions made out of fear or during times of grief, you're not going to get a good result. And that's why we're here to look at your budgets, to make sure you're on track, keeping the wheels on your life. And again, if your goal is to preserve your assets for your kids or your grandkids, we balance that out, and we balance that by getting to know you. And so,
I have a question.
yeah,
What if you don't have a healthcare directive or you don't have the financial power of attorney? Then what happens if you don't have it?
yeah, they're going to assign you somebody. And if it's a capacity issue, unfortunately, you're going to get conserved. And that is another nightmare. That's very expensive. There's attorneys, for the person who's trying to conserve you. There's an attorney for you to try to preserve your rights. And it's really bad because, thank you, Britney Spears, if you're able to feed yourself and, pay a bill here and there, they're going to say, oh, they're fine. But we all know that people could have a myriad of things going on and really, truly do need the help, that it has to go to that extreme, right? You're conserved or you're not getting help. So that is not really a good alternative. It's much better to have at least these two documents in place, have somebody is actually going to show up. We have literally been at the hospital with the fuzzy slippers, the toothbrush, and the cell phone. Who's going to do that? Maybe your kids are lovely and perfect in every way, but they live far. They're not going to be able to have that kind of response time. So, we're kind of people who've never heard what a fiduciary is. I tell them this: we're professional kids. We're the ones who went to school and, did great. And we're going to do the best thing for you all the time. We're not going to resent you. We're not going to push you off. We're going to look you in the eye and say, what do you need? What can we do? What's going to make it work?
So you have a team of people that do all this, or do you do it all by yourself?
Oh gosh, no. And so that kind of goes to what Ruby was saying. And the gentleman who already left, I'm plenty young enough to handle that 86-year-old whippersnapper there. But yeah, so I have a team of younger fiduciaries. I have a team of associates who do care coordination, and everything is under my supervision and the supervision of the other fiduciaries there. However, we try to make it cost effective. So if they can do the duty and the task, we let them handle it. And you know what? That's why I didn't name my company Paladin Fiduciary Services after me, because it's going to keep going after I'm gone. So that's it. Unfortunately, a lot of the fiduciaries are solo practitioners and they do not have a succession plan. And they are practically needing fiduciaries themselves. I don't know why this is such a secret career, because it's fabulous. In California, 40 million people. Very conservatively, 25% are seniors. There's only 800 licensed fiduciaries practicing in the state of California. So, and 1 million seniors are in crisis and need our services today. It's not optional. I'm talking adult protective services and the like. So wouldn't you rather pick your own fiduciary now and secure that? And that's where it's out. The fields are ripe and the workers are few. So parents with multiple children, Do you remember that old show, The Smothers Brothers? Mom loved you best. Mom loved you more. And that doesn't stop. Let me tell you, and parents are so cute. Oh, my kids would never do that. You know, I have a saying where there's a will, there's a relative. Okay. So it's just, they are going to turn to 12 years old again the minute you leave the planet. They are just going to just be paranoid. And why did you get to be picked to be trustee? How come you're the executor? Show me where all the money is going. How come, where's my check? That's what we say in the office. Where's my check? Because it's like they're not getting communicated with. Because the person who got picked for this great role is trying to juggle all this emotional baggage, plus deal with their siblings. It's a horrible, perfect storm of hate, paranoia, and jealousy. And frankly, they never talk to each other again. However, conversely, where you have a fiduciary who can direct all the drama and the traffic and keep everybody civil, deal it all out, and then they can deal with their own emotional stuff, you get a good outcome. And that's why I love doing this work. It preserves families and family harmony. So again, you know, when you have very different financial situations between the siblings, where you've said, you know, everybody gets an equal share, but maybe so-and-so's on, you know, Medi-Cal and the other one lives in a couple $1 million home. The one, you know, who's feeling gypped out, I can't even say that anymore, who's feeling that they've been robbed, you know, how do you balance all that? There's no answer as between the siblings. You need a counselor who can navigate this. And this is what professional fiduciaries can do. And so, you know, we just don't want to have that thought that one kid, like in the Smothers Brothers, was favored and the golden halo was somehow floating over their head. We just want to keep everybody on an even keel, and everybody can feel secure that their parents thought of them, they were planned for, they were loved, and so forth. So now, again, the living trust, it's all the same stuff that I keep hammering in. Equal treatment, professional mediation, objective distribution decisions, preservation of family relationships, and same with the healthcare. You know, you should name somebody who's nearby for those emergencies. And, you know, we can, on the document, it says, when do you want this to become effective? Now this, Ruby and I talk about this all the time. It's silly. Only after I lose my marbles? Wouldn't you rather know me beforehand and see me in a couple situations and how we work together? And, you know, once you're out of it, it's like, that's when you're going to start trusting me. It's just weird. And so I've been in situations where people maybe are bordering on some cognitive issues. And I will say, you know, I see they're starting to loop, and I will go to make an appointment, say, hey, can you give them a MOCA test, which stands for Montreal Cognitive Assessment. And they say, well, who are you? And I'm like, well, I'm their power of attorney for healthcare. Okay, well, send us the paperwork, of course. Send the paperwork. Oh, well, it says that you're only the power of attorney for healthcare after they've lost capacity. Well, I'm trying to get them tested to see what their capacity is. Sorry. So you can see it gets stymied just by a simple check of a box. When to make your power of attorney for healthcare effective. And again, I'm not coming in and trying to, you know, put you in the funny farm. I've got too many clients. I've got too much other stuff to do. I really just want to be there for you when you need me and how you need me. Okay? So it's really important. And again, to emphasize, these powers of attorney are only while you're alive. You go away, these powers go away. So Yes.
I don't mean to cut you off, but are you going to talk about trusts?
I
have
can't.
I have a couple.
Yeah, I can a little bit, but just unlike Ruby, I kind of want to get through this, and then we'll do questions and answers at the end. So for people who reaching their threshold, not trying to make you glaze donuts. So yeah, again, so what if you have one child? One child. They're both the oldest, the youngest, the middle. They got it all on them, right? It's an overwhelming responsibility to put on one kid, especially how many estates have they administered? How many powers of attorney have they been agents for? And I'm sure there's enough experience in this room where you've had to deal with your parents' estates at some point and in some way. So you know what fun that is. So there's no siblings. They have nobody to vent to look to share the burden of administrating your estate. And they may, again, live far away, have a demanding career, have kids of their own. They just don't have the bandwidth to help you out. And it's nothing personal. And then if they're physically taking care of you, wow, that is just a setup for burnout. And so, we really need to get you the caregiving and other kinds of things that you need. So it's give your child the gift of professional assistance, or your friends, whoever it is. Let them stay in their roles that they know you in. Let them maintain that.
Quick question. If the parent passes and the child is now the executor, can the child hire you at that point?
Yes. And so I'd like to emphasize that sometimes we are only an agent on one document. We might just be the money people paying their bills every month because that's all the help that they need. I just need somebody to pay their bills. Sometimes we're the power of attorney for healthcare. Sometimes we're only the trustee, or only the trustee of the special needs trust, or only the executor. And we have other family members named, or other people for whatever reasons are named on these other documents. And we take a team approach. Did that answer the question? Okay, great. So I think we talked about that we want you in part of your estate planning to really understand that while you think it's such a great position of trust, which it is, it can become a very taxing burden that most people are not prepared or have the requisite experience or knowledge to deal with. So again, this goes to the shared responsibility model. And we handle the complex financial and legal matters, and we love to give kids something to do because they do want to be of service and use. And we play to their strengths, and we figure out how much time, how deeply they want to be involved, and we ask them to help in a meaningful way. And again, having this shared responsibility model reduces the stress for your child and just you as your peace of mind, knowing that we're a part of this. And so we also seek family members' input about, especially if you've lost capacity, well, you knew your mom or you knew your dad, what kinds of things are going to help stimulate their memories, and what do you think? But again, we do a lot of onboarding to make sure in advance of those events that we understand what you want. And we also are very sensitive to the fact that those things can change. So you get expert financial management, before, during, and after your capacity, whether we're teaming up with your advisors or we're overseeing your finances ourselves. And we are available 24/7. Absolutely. We always have somebody answering the phone. And it's surprising because people are like, oh, I thought I was just going to leave a message. It's like, no, we don't have that luxury because we don't know it's an emergency or what you need, but we're always there. And then, so why would you choose Paladin or any fiduciary service? And again, because we're licensed and we're legally bound to act in your best interest. We have the expertise. This is our day job, not a crash course and where something is going to get missed and fall through the cracks. We're objective. We have no, forgive the expression, we have no dog in the fight. Our only goal is to make sure your wishes are respected, fulfilled. And, you know, our professional services are available when you need them and to the extent you need them. It's just not all or nothing. Yes.
I have another question from Zoom. Where are you located? Are there team members based in Marin? And what is your last name?
Well, my last name is Merrill, like Merrill Lynch. No, I'm not related, obviously. And my office is located in between Santa Rosa and Sonoma. It's in an elder community in Oakmont. However, I do have a fiduciary and an associate who are located in Petaluma, which is very close to you guys. So, okay. And so, and again, getting back to the structure of the company, it's going to pass on after I either retire or sell or whatever happens there. We have 9 folks working for us. I keep growing. My the gentleman who has the building where I'm at, he's like, "Oh, you're renting another room." And a couple more months, "Oh, you're renting another room." And so I've got people crammed into corners, but everybody is very inspired by this work. Right. So I have other fiduciaries and I have other associates who I have handpicked and trained because of their special qualifications.
They're licensed as well if they're
Yes, I have
fiduciary.
licensed fiduciaries and I have other care coordinators. Licensing is not required, but again, they have expertise either in psychology or social work or other areas of accounting and so forth.
I'm sorry. When we hire you, okay, and we will need, let's say in 1 year, really, then we will need you. So we will hire you, we will pay you ahead or how?
Okay, so thank you for asking. No, we earn our money. Okay, you're going to know when we've done something for you. Now, there is an onboarding once we're named, but that's because we need to spend some time reviewing your documents, not because we think that Ruby did anything, you know, wrong, but just to understand, are they effective immediately? Are they effective after you've lost capacity? Getting to know, you know, do you want to be cremated or do you want a mausoleum? Or who can we talk to in your family to team with, like if something were to go south? So we spend a little bit of time. There's an onboarding fee. But other than that, no, there is no charge unless you invite us or there's an emergency situation. Yes.
This is the first time I've heard of professional fiduciary. What does it take to become one?
Unicorn dust. So you have to have a bachelor's. You have to take fiduciary classes. You have to pass an exam, which tests both California and national laws regarding guardianship and conservatorship and other areas that fiduciaries practice in. There is other paths besides that, but it would take like 5 years of very related experience. Like you'd have to be a trust officer at a bank or some other, or a nurse. You know, you could have an associate's, but then you still need on-the-job experience to be working under a fiduciary and get signed off on that. My background, I have a Bachelor of Science of Real Estate, so I'm very attuned to that piece. I'm a certified professional fiduciary, so I went through UC Riverside. It's a management program. I also have a Juris Doctorate in law. So getting back to I want my family involved. And again, we welcome family. We work with your family, not instead of them. Your loved ones remain involved with all the decisions, and we handle the complex and financial matters. However, if there's a particular family member you're like, I don't want, they can talk, but they are not, they don't actually get a vote. We're fine with that too. And getting back to the cost piece, our fees are on the website as is required by law. Any fiduciary has to have their fees posted. We are about less than a third of an attorney. So even where there's situations where it's like, well, I still really want to name my kid, that's fine. But kids end up going to attorneys. Okay. And so it's not really a cost savings by naming your relative or your family member. They still don't know what to do and they need heavy guidance, and it's still an expense. So why not have an affordable alternative? Even if I'm playing no role in your estate, I can still advise a trustee. And also too, even when I am named, I absolutely have many attorneys on retainer. So if I feel that I've reached the edge of my experience or knowledge, I consult with them, but it's still at a very significant savings. So will they understand my wishes? You bet. Again, that's part of the onboarding process. We take time to get to know you and what is really important to you and what you want. And so sometimes I have people like, well, I want to donate my body to science. Great. But most people don't know, if you don't have a contract with that receiving entity, they will not take your body. And unfortunately, your wish to further science will not be honored. So these are the types of nuances and details that professional fiduciaries are there to make sure your wishes are honored and come true, whatever you envision. So I'm heading towards the last slide here. So really, don't wait, because I want you, when you're of sound mind, even if you're not of sound body, and I want to get to know you, and I want to get to know what's important to you and your spouse. And so you can schedule a consultation. We can review your current estate plan, and either somebody like Ruby could help refresh and update it if things have changed, which they usually have. And we can discuss your family situation and concerns. And I've heard everything, so there's nothing to be embarrassed about or concerned about. It's all confidential. And we really want you to learn more about what professional fiduciary services can do for you. So we also are very dedicated to preserving your legacy. And so we would love to get to know you better. So by all means, you can contact me at Paladin Fiduciary Services. And any last questions, and I will hang out too. Go ahead.
Sorry. I just want to know if you have business cards back here, because I don't see a phone number up there.
Yeah. So, again, I'm not here to hard sell. I would rather, give you my phone number personally, if that's actually something you're interested in. And just, I do have some brochures that are at the table where Fran is, and they do have my telephone number on it and my website and all the things.
Also, we will, I'll send out an email. It'll probably might be Friday or early next week, that will have have Ruby's contact information and Lori Beth's contact information, a link to the recording and any other handouts and stuff they might have, and where you can find previous. We have all the recordings on our website, so you could look at other ones as well.
One more question from
Sure,
Zoom.
absolutely.
Your name and the company name is different. Are you part of a larger corporation?
So again, the reason why I name my company Paladin, first of all, Paladin means strong advocate, champion of a cause, which I thought was super appropriate for a fiduciary business. And again, I'm not always going to be part of the business, and it must continue on without me. And so that's why it has a different name than me, unlike other sole proprietors who name it after their last name. And when they go, it goes. Any other questions? Yes.
So would you or your team start working with a client if they did not have estate planning documents?
No, that is absolutely requisite.
Okay.
Because, you know, it just doesn't make sense, because if something goes south and no one has authority to act for them, we've really done them quite a disservice. Does that make sense?
So I'm just thinking in terms of steps, get your documents in place.
Yes.
Get an attorney.
Yes. And then you would
Follow.
come to us. Absolutely. But if you want to just meet us and find out more about fiduciary services, we welcome that. It's just, we've had other people. It's like, well, can you pay my bills? It's like, well, how can I pay your bills if I have no authority? So these documents give us the authority to act for you. And the other thing is they're revocable. What if you say, well, I'm just tired of that, Lori Beth, get her out of here. Well, you can revoke it. There's no hurt feelings. It's all about fit.
And it's not a terrible idea to meet with Lori Beth in tandem with getting your estate planning documents, because if you are going to name her in a role, then you should know who you're going to name in these roles as you're meeting with the attorney and getting the documents prepared.
Exactly.
So you
Thank you.
can
Well
do them
said.
kind of on a parallel track.
Yeah. Thank you, Ruby. Anything else? Anybody else? Going once? Going twice?
Somebody had a question. Sir, you had a question about trust? Oh, okay.
Okay, I will talk to you after. Well, listen, I really appreciate your time. I know we've gone long. You've been wonderful. And again, Paige will be sending out everything. And feel free to email me, because it's a lot to unpack. And again, as she said, this is the first time she ever even heard of a professional fiduciary, you know, the surrogate kid concept. So I'm sure you're going to have some questions. And by all means, please email me. I will respond. Okay. Thank you so much, everybody.